Mr. Coleman, for the reasons discussed, and I'll put myself in the same example, if I had just been to a musical event and had heard talented musicians offer their rendition of a particular song or series of songs, and I was asked to sing, having never sung in public, maybe not even being familiar with the songs, I'd feel like I was being put on the spot. I'd feel like I was being, is the MC trying to just put me on the spot and humiliate me with asking me to get up and follow these series of musical renditions? So that's not a criticism of your personal integrity or dignity, but based on what we've already talked about in this hearing. You are welcome to comment if you choose to, and if you choose to, we're all going to listen to them. You are welcome to take the alternative that I mentioned of having counsel review this and follow up if you make that decision. So that's entirely up to you.
Thank you, Your Honor. Thank you for the opportunity.
May I clarify, Your Honor? Does that mean if he comments we're done with the counsel and he does not give a second bite?
Well, there's one area, frankly, that I'm a little less formal than what one would be customary. As long as anyone has anything reasonably relevant to the issue, in fact, I'm going to hear from everybody today that has something to say, even if it's really kind of out of sequence, even if it's some repetition, even if it brings up a new issue, because I think it's important to have it said if somebody needs to say it. So that's a muddled, Mr. Harris, that's not an over and yes, that's a maybe, I guess.
First of all, I intend to retain counsel, Your Honor. Second of all, thank you for the explanation of the shadows. And I know it's a difficult decision. What I bring to the table is I know the material, and I definitely know the relationship between the IDA and CLA. I know that relationship, and I know about the engagement between the IDA and Larson Allen. And I know that relationship that they've had over the years on these various audits, agreed upon procedures with rapid systems and various things that the IDA has asked Larson Allen to do for them. And I know about all of these various meetings and mentioning we're going to have Larson Allen, we're going to have them look at this, and we think we can get $2 million more for CareSync, and we're going to do this. I know about every single one of those things, and I know how this came about, and I know how this thing grew from just mentioning to get the last $990,000 in September of 13, and I know how this thing came about, and it was a verbal agreed upon procedure. And then it grew into a little bit more and a little bit more, and then it was going to be a little bit of an audit to get a $2 million more. My point is this.
Objection, Your Honor. May it please the court, Mr. Coleman is not encumbered by the record or the sworn affidavits of record. He is speaking strictly with his opinion and what he knows, and that is totally improper at this stage of these proceedings. We object.
It's not legally, it's not material that is subject to admissibility at a trial in evidence, which is the standard for reviewing a motion for summary judgment. But I want Mr. Coleman to be able to respond to the argument he's heard to the extent he wishes to.
It's the gray area. See, you're bringing up a point. It's not black and white. So, Your Honor, when you're looking at this gray area, were they an agency or not? Were they independent? Were they over here, in a dark room doing it with their green eye shades on, doing their thing and saying, when we get done, we'll hand it to you? I'm saying that's not the way it happened. This thing was a collaboration. And you can watch the way it progressed and the way it came out. And that's why you see today that it's still not done. That examination audit never got finished. It's still not done. And the grand jury and all of this stuff never got done. So my point is this, the
Objection,
engagement.
Your Honor. He is, and forgive me, I take your point that you really want to let him put on the record what he would like. But my fear is that an objection not made is waived in these situations.
And noted.
But he is going well beyond the record. Now he is apparently about to launch forth into grand jury proceedings, which
No, I'm done.
Pardon me?
I'm finished. I'm going to stop.
Objection noted.
The nature of the engagement of CLA will be shown that it was not, that they were not an independent agency, and it was not an audit. It was an agreed upon procedure. It was not an audit that turned into a quote an examination. It was never deemed an audit. That was my first point. The second thing, and I take the state's position on 119. The burden of proof when it comes to confidentiality, 288. The burden of proof in 119 rests with the custodian. It's clear. The custodian, it's their responsibility. It's their responsibility to take upon establishing the burden of proof if an exemption exists, and just following the procedure normally. But in this case, the state said correctly, Ms. Avalon was sitting here, and in her stipulations of fact that she put out early in this case before June 10th when they left, she clearly said in this case
That's
that
not
burden of
correct, Your
proof.
Honor. There was no stipulation. The fact finally entered.
I did not, I haven't seen a stipulation of fact. Let me say, a judicially approved stipulation of facts.
It was a notice of stipulations. It was a notice, very
That-
long.
That is a record, a notice of
It was a
stipulation.
notice of stipulations.
But recall, that's the one we objected to because the stipulation was not an agreement as stipulations usually are.
I agree with you.
It was it was characterized, well, actually it wasn't characterized, it was designated as a stipulation by the state as a willingness to assent
Yes.
to these being the facts, but there was never any,
It was,
in the sense, or actually within the requirement that stipulation necessarily must be bilateral between at least two parties. It was an acknowledgement or willingness to stipulate, but no other party actually
it never
stipulated.
got that far.
It's a proffer, it's an acknowledgement, it's not technically a stipulation.
Yes,
But,
sir.
I don't,
But in that document, in that document, she said, because.
Objection. Again, that is not a document that can be relied upon at this point in the proceedings.
I know that, but, Ms. Coleman,
In
address
that,
what you want.
in that list, in that piece of paper, she said, normally, the burden of proof rests on these exemptions. Confidentiality, burden of proof rests with the custodian. In this case, the custodian that normally would have those records. So since in this case, it would be the IDA. But in this case, since it's Kirsten, this doing the trade secrets, that burden of proof rests with Kirsten. And it would be Kirsten that would have to pay for the fact finding to establish what records are exempt. And that's all I have to say. And then do the rest of it. Thank you.
Coleman, thank you.